fire burning in my belly. And I can hear my mama calling me. Hear my mama calling. Come back to me now. I can hear my mama calling me. Hear my mama calling me back. Calling me back. Way down that never ends. I can hear my father calling me. Hear my father calling. Come back to me now. I can hear my father calling me. Hear my father calling. Come back to me now. Come back to me now. Come.
The Maccabees. We're listening to a cappella music now during our countdown because we're in the 3 weeks. We observed the fast of the 17th day of the Hebrew month of Tammuz a week ago. And this Friday is going to be Rosh Chodesh Av, the first day of the Hebrew month of Av. And then we enter the 9 days. And at that point, we can't listen to music at all. So I guess starting Friday, during the countdown at the beginning of the class, maybe I'll just light the candle so you'll know something's going on, not, wondering why there's no sound coming out during the countdown itself, but no music during the 9 days, right? When we start the Hebrew month of Av, we start counting down to Tisha B'Av, the 9th day of Av, the saddest day on the Hebrew calendar, the same day on which the first temple and the second temple were destroyed, as well as numerous other calamities in Jewish history. So no music during the 9 days, only a cappella music during the first half of the 3 weeks, which is what we're in now. Already diminishing our joy a little bit, and during those 9 days especially. And then there's the famous story that at one time Napoleon was walking by a synagogue during that period. It might have even been on Tisha B'Av itself. I think it was on Tisha B'Av itself. And he heard weeping going on in this synagogue. And he asked his assistant, what's going on in there? Why are all these people crying? The guy went in, came out, and he said, those are Jews, and they're crying over the destruction of their holy temple. And Napoleon said, who destroyed the Jewish temple in my empire without my permission? I want to know immediately. And the assistant said, no, they're crying over a temple that was destroyed almost 2,000 years ago. And Napoleon quipped, any people that weeps for 2,000 years over the loss of their holy temple will merit to see it rebuilt. And so we pray that that day will come soon. But this is that period where we diminish our joy. Still, we're not in the 9 days yet. Let's light up the darkness. All right, who's with us? We're only doing one page today. We can move at a nice pace and really cover it thoroughly. It's a short page, so we can just get into it. It's going to be great. Shandora in the Bronx, Stephen in New Hampshire, Paul in Chicago, Sharon in New Jersey, James in Annapolis, Ira says shalom y'all. Guy in Dayton, Ohio, Nancy in North Carolina, Paul in the Great Northwest, Yehuda in South Carolina, Sandy in Michigan, Melissa in Great Neck, Bella in Florida, Paula says shalom, Renee in Indiana, Carolyn in Raleigh, Lucy in Minnesota, Bill in mid-Missouri, Aoife in Florida, right? Lee in Texas, Lewis in Northern California, Bev in Naples, Iridancia Haddad says shalom. Yeah, Yehuda says amen. Zach Plotzker, my man, tomorrow is the day we're praying for your refuah shlema, a complete recovery to perfect health for you. Zach, Yitzhak Shlomo ben Miral Devora, may you have a refuah shlema. Christo in Lubbock, Texas. Bill, oh good, a nice page we can chew on it instead of having to scarf down. Amen. Over there on the YouTube side, John from Sedona checking in. Rochelle and Modesto. Marianne Coughlin, wow, checking in from near Boston, right? Great to have you with us, Marianne. Gwen, Michigan is in the house. So glad to see you all, my friends. I'll just share. I sound good, thank God. But, last night we were having dinner, and Nina's such a wonderful cook. I mean, she really makes amazing food. Last night we had chicken and a vegetable and a salad, and I bite into the chicken. I'm like, wow, this is really bland. Did Nina forget to season it or something? It's impossible. And the salad, wow, this salad has very little taste. Does it have dressing on it? And I thought, oh no, I just got back from this trip. Is it possible? Could I have COVID? I went over to the spice drawer. I take out the spices, rosemary, nutmeg, clove. They all smell like they're 20 years old. Very muted odor. So I took the COVID test and, took one of the viral tests that you're supposed to wait 15 minutes to see if the positive line appears alongside the control line. And in 30 seconds, it just showed right up. So I tested positive for COVID. I dodged it, more than 2 years into this pandemic. Thank God I didn't get it till now. But okay, so now I have a positive test. I'm laying low. So far, thank God, the symptoms are light. And today I ate some food and I could taste it. It's like my sense of taste is diminished, my sense of smell is diminished, but it's not gone. So please God, may it not get worse, may further symptoms not develop. I talked to my doctor, we have a plan. But I would appreciate if you say a prayer for me that I should have a complete healing. I know there's many people on the planet who have it much worse than I do, and may they all have a refuah shlema, a full, complete healing of body, mind, and spirit. We say amen. Okay, we are holding. Today's daf is Chaf Aleph, right? Chaf Aleph, page 21 here in Tractate Kesubos, the 15th volume of the Talmud. We are in chapter 2, today opening with Mishna number 3. Recall that this tractate generally is the laws of the marriage contract. And specifically, the marriage contract was instituted by our sages for the protection of women. Since under Torah law, the right to divorce is a unilateral, patriarchal right of the husband to make sure that a husband wouldn't cavalierly say, you know what, I'm tired of you, and just send his wife packing. The sages made it expensive, sometimes very expensive, to get a divorce. So this was for the protection of the women. Really what it institutes is that in the event of a divorce or the man's death, she's going to get a minimum amount of money. And as we saw yesterday, the sages established that it's basically a year's salary for an average person is how much money. And that's a minimum. You can certainly establish a ketubah or a kesuva in Ashkenazi pronunciation in higher amounts. But now that we're talking about a contract, and all contracts, for them to be official and valid, have to be witnessed, right? So there's going to be two witnesses who sign their names on the contract, and then the contract can be lost. The witnesses maybe are not found. Problems can be found in the contract itself. And so even though we're talking about marital matters, as it were, in a marriage contract, now we're really starting to talk a little bit more generally about laws of contracts, laws of evidence pertaining to contracts. Was the contract established? Was it signed? And now this is going to extend beyond just marriage contracts to any kind of a contract. For example, a loan document, right? If somebody lends money to another, the contract is in the form of a promissory note. You lent me this money. I promise to pay it back. Two people witness that the loan was made. Now this document represents the liability of the borrower to the lender. And in the ancient world, this body of law was not as sophisticated as it became under the rubric of our sages, and it became a very, very extensive, systematic, sophisticated body of law. And now we're starting to get into that. So here's Mishnah number 3 in chapter 2. And you'll see that right away. It extends well beyond the area of marriage contracts. Mishnah number 3. If this witness, whose name is signed on a document, says, "This is my handwriting, and this is the handwriting of my fellow witness," and that witness says, "This is my handwriting, and that is the handwriting of my fellow witness," these witnesses are deemed credible, and the document is ratified, as together they provide testimony authenticating both signatures. So right away you see, why are we talking about that the witnesses who signed the document are brought in to testify, yes, that is my signature on the document? Presumably something went wrong, right? The borrower said, "I will pay," and when the time comes for him to pay, he says, "You know what, I didn't borrow," or "I already paid." These are the kinds of things that can come up. Or perhaps the borrower died, and now the lender comes to present the promissory note to the heirs of the borrower who died, right? Comes to his son and says, "Well, your father borrowed money from me." The son says, "I never heard about such a loan. I'm not going to pay back this loan that I never heard of. Here's the promissory note." And the guy says, I don't want to pay. So we go to court, right? So when things go wrong is when you end up in court. And, it's like the job of the transactional lawyer is to create the contract, and the job of the litigator is to figure it out when things go wrong. And you go to court, and now it's the judge or the panel of judges who are going to have to decide how this thing is going to come out. So what we're talking about is how the judges in court are going to evaluate, is this a valid contract? Now, in today's day and age, we're just used to contracts everywhere. The digital age was supposed to reduce the amount of paper being used in the legal system. It has only amplified and multiplied it, to extremes. Maybe now a little less because people are accustomed to digital documents. But sort of the beginning of the word processing age only just made documents, contracts, go from 10-page documents to 100-page documents, and 100 of them to represent one transaction, etc. But in the ancient world, it was like short documents represented the whole transaction. And people didn't have multiple copies of everything. And it was like the one copy was the one that really mattered. Because in fact, you wouldn't have copies of contracts that could each then be used to represent and call a loan. So they took these documents very, very seriously. The contract itself, right, it didn't just represent the transaction. It's what we're going to adjudicate when trouble arises. And so you go to court with that contract, and the ones who signed it may be called in to testify. And the question that we're examining here in this Mishna and the Gemara that follows is, when the witnesses are called to court to say, yes, I signed that document, that's my signature, are they only testifying to say, that's my signature, or are they actually coming to testify and say, I witnessed the loan. I saw John lend Tom 100 dinars. That happened in my presence, and Tom promised to pay back the amount of money in the future, or perhaps on a schedule that's specified in the contract. So is the witness just coming to say, I signed it, that's my signature, especially if it happened many years before? Maybe the witness doesn't remember the terms of the loan, but he can say, yes, that's my signature. So is he testifying to the occurrence of the loan being made, or is he simply testifying, yes, that's my signature? Let's go on. So it starts by saying that one witness comes and says, that's my signature, and that was my co-witness, and that's his signature, right? This is my handwriting, and this is the handwriting of my fellow witness. It's not even that's my signature, it's this is my handwriting. That's actually a step removed. This is my handwriting, and that is the handwriting of my fellow witness. So these witnesses are deemed credible, and the document is ratified. as together they provide testimony authenticating both signatures. It's like they're a pair of witnesses saying these two signatures are valid. Now, if this witness says, this is my handwriting, and the other witness says, that's my handwriting, so if that's my handwriting, and neither testifies with regard to the signature of the other, right? So it might be that these witnesses know each other and they can each say, this is my handwriting, and I know my fellow witness, I know that that's his handwriting, so each witness can say both signatures are valid. But if the witnesses come in and they only know their own handwriting, can only testify to the validity of their own handwriting, so that's a different situation. Because what have you got now? As to the validity of either signature, only one witness has established that that is a valid signature. And generally, as we have seen, to establish a matter in a Jewish court, in a rabbinic court, according to Torah law, requires two witnesses. So if what we're establishing is that the handwriting is valid, that the signature is valid, well, per each signature, only one person has said that signature is valid. So if this witness says that's my handwriting, and the other witness says about the other signature, that's my handwriting, and neither testifies with regard to the signature of the other, they must add another witness with them who will authenticate the signatures of the two witnesses. Why? Because otherwise, each of the witnesses would be testifying with regard to half the sum in the document. This is the statement of Rabbi Yehuda Hanasi. This is kind of interesting that they're getting into this idea where if you need two witnesses to ratify the document, so you would think that, well, either you have two witnesses and the document is valid and so the whole money is owed, or you don't have two witnesses, in which case no money is owed because there's no valid document. But here they're sort of dividing the validity of the testimony and saying, well, one witness is coming to testify, and once that's ratified, it represents half the amount represented in the document, and the other witness is coming to testify, and his testimony represents the other half of the value of the money owed in the document. So it's like each one is his testimony is worth half of the loan, in this case, if we're talking about a loan agreement. So let's just read that. As otherwise, each of the witnesses would be testifying with regard to half the sum in the document. This is the statement of Rabbi Yehuda Hanasi, Rebbe, who edited the Mishna. But the rabbis, meaning the majority who disagree with Rebbe, say they need not add another witness with them. Rather, each one can testify about his own signature, and that's going to be enough. Why? Because a person is deemed credible to say, this is my handwriting. The testimony of the two signatories about their own signatures is sufficient. Now that, I think, makes a little more sense to us, right? The two witnesses originally witnessed the making of the document. Now they're called back to say, is that your signature? Yes, this is my signature. So again, you have two witnesses saying that this document is valid, and that should be enough for the court to ratify the document and say the document is valid, the lender owes the money. But if they're only testifying about the validity of the signature, you might say, well, if he's only testifying about his own signature, then only one witness has established whether a particular signature is valid or not. And that's why Rebbe says bring in a third witness who can join with both parties and say, yes, that's a valid signature. So vis-a-vis each signature, you've got two witnesses testifying to its validity. Right, so the open question, are they testifying about the loan that was made, or are they testifying about the signature on the document? That's our Mishnah. Here's the Gemara. The Gemara says, when you analyze the reasoning for the opinions of the Tanaim, the rabbis of our Mishnah, you will say that according to the statement of Rebbe, Rabbi Yehuda Hanasi, the witnesses are testifying about their handwriting, and they are authenticating their own signatures. Therefore, if each witness testifies only with regard to his own handwriting, there's only one witness authenticating each signature. Whereas, according to the rabbis who disagree with Rebbe, the witnesses are coming to court to testify about the original loan. In this case, 100 dinars that is in the document. That's the example that's being given, 100 dinars is a loan, or here in the world of ketubahs, that was the amount established in a marriage contract for a non-virgin, right? A divorcee or a widow, when she gets married, is entitled to a 100 dinar document. At any rate, they're coming to say, we witnessed, they agreed that 100 dinars was represented by this document. So the Gemara asks, that is obvious. No analysis is necessary to arrive at this explanation of the dispute. We get that from the Mishna. Rebbe is saying they're coming to testify about their signatures, and the majority of the rabbis are saying they come to testify about the original exchange of value. So the Gemara answers, the analysis is necessary. It is not so obvious, lest you say that according to Rebbe, there is uncertainty whether they are testifying about their handwriting or whether the witnesses are testifying about the sum of 100 dinars that is in the document. And due to the possibility that the purpose of the testimony is to authenticate their handwriting, he requires 2 witnesses for each signature. It's not that necessarily Rebbe says the only reason they're coming here is to validate their signatures, and that's why we would need 2 witnesses per signature. It might be that Rebbe is unsure whether the law requires that they come to validate their signatures or whether the law requires that they come to testify about the original underlying matter. And the practical difference between whether the opinion of Rebbe is based on certainty, that we are just establishing the signatures, or uncertainty, whether we're establishing the signatures or whether they're coming to testify about the original loan, what difference does it make? The difference, the practical difference, is in a case where one of the witnesses who signed the original document has died. If Rebbe's opinion is based on certainty, that the witnesses come to testify about the validity of the signatures themselves, so then one other witness testifying to the authenticity of both signatures would suffice, as both that other witness and the surviving signatory would testify to authenticate each signature. So vis-a-vis each of the signatures, there are 2 witnesses saying that's a valid signature. However, if Rebbe's opinion is based on uncertainty, he's not sure about whether the witnesses come to establish the validity of the signature or to testify about the original loan, then let them require 2 other witnesses from the street to testify about the signature of the deceased witness. And that is due to the fact that if it is so, that the witnesses are testifying about the sum of 100 dinars that is in the document, the original transaction, and only one other witness joined the surviving witness in testifying with regard to that signature, the result would be that the entire sum of money, less 1/4, is collected based on the testimony of a single witness, right? Because the single witness established his own signature and joined in establishing the validity of the signature of the original witness who has since died. The surviving signatory authenticates his signature and thereby facilitates the collection of half the money. In addition, his testimony, together with the testimony of the witness from the street, authenticating the signature of the deceased signatory, facilitates collection of the other half. So based on the verse, at the mouth of 2 witnesses shall a matter be established, Deuteronomy 19:15, each witness is responsible for half the sum. But here, since the original signatory, signing witness has died, the one who is still around ends up being, like, his testimony is too important. It establishes his own signature and is half the testimony for the guy who died, and it seems like we're relying too much on this one guy. And one would have thought that Rebbe would rule stringently here. When both signatories are alive, they must add another witness with them to authenticate the signatures of the 2 witnesses, as perhaps they are testifying about their handwriting rather than the original loan. And he would rule stringently here. When one of the signatories died, they must add 2 witnesses, not just one, as perhaps the witnesses are testifying about the sum of 100 dinars that is in the document. Therefore, the Gemara teaches us that the matter was clear to Rebbe, that they are testifying about their handwriting, and he ruled both leniently, requiring only one additional witness when one of the signatories died, and stringently requiring an additional witness when both signatories are alive. As Rav Yehuda said that Rav said with regard to two witnesses who were signatories to a document and one of them died, they require two others from the street to testify about the signature of the one who died. And in this case, Rebbe rules leniently and requires only one additional witness. And the rabbis rule stringently and require two additional witnesses. And the Gemara asks, and if there are not two witnesses capable of authenticating each signature, but only one, what can be done to ratify the document? Right? If what we need is witnesses to come in and say that is a valid signature of the witness who saw the original transaction, and that's how we're ratifying the document, well, what if you can't produce two witnesses to ratify each signature? Can you ratify the document or not? Right? You could ask similarly, if the witnesses are coming to say, I witnessed the original transaction, and those witnesses have died or are not available, and we can't find those witnesses, how can we ratify the document? First, let's talk about if we don't have two witnesses for each signature. So if there are not two witnesses capable of authenticating each signature, but only one, what can be done to ratify the document? Abaye said, let the surviving witness write his signature on an earthenware shard and cast it into the court. And the court then ratifies the document by seeing that it is his signature, right? So the surviving witness, let him write down his signature, and then they can compare his signature to the signature that appears on the document. Why is he writing it on an earthenware shard? That will be explained momentarily. So that way, he's not coming to testify about his own signature. The judges are going to be able to judge for themselves. Is his signature on the document the same as this man's signature who is before us? And that way, this man who knew the other witness and saw him sign his name, he's not coming to testify about his own signature. He's only coming to testify about the signature of the other witness, the one who has died. And so the court ratifies the document by seeing that it is his signature, comparing it to the signature he just made on an earthenware shard. And then this witness does not need to testify and authenticate his own signature. But he and this other witness who can ratify the second signature, they go and testify to authenticate the other signature of the deceased witness. In that case, even according to the rabbis, one additional witness is sufficient. Now the Gemara notes, and he writes his signature for the purpose of comparison, specifically on an earthenware shard, but not on parchment. Why? Due to the concern that perhaps an unscrupulous person will find it and write on it whatever he wants. For example, the undersigned owes him money. Right? Now you would think, you're saying that somebody just wrote on a scrap of paper his signature so that we would have an example of his signature, and then, they lose track of that scrap of paper and some guy picks it up off the street and says, aha, look, this is the signature of Sal Litvak. I'm going to add on top of it, I, Sal Litvak, promised to pay Joe Schmo 100 dinars. Here's Sal Litvak's signature, and now they can go present it to a court as a loan document, as a promissory note that Sal Litvak wrote. We would think that's ridiculous. It doesn't look like a contract. It's not a 100-page loan agreement. But like I said, in the old days, paper and documents were not so common, and you might actually have a promissory note on a scrap piece of parchment because parchment itself was dear. There wasn't so many scraps of paper floating around. So you don't want your signature on a piece of paper where there's room for an unscrupulous person to, add the language of a promissory note above it. But nobody writes a promissory note on an earthenware shard, and that's why for the writing sample, you would do it on this, piece of pottery. And we learned in the Mishna, Bava Basra, page 175b, if a creditor produced a document about another, written in the other person's handwriting, in which it is written that the other person owes him money, even if there are no witnesses, he is obligated to pay, and the claimant may collect payment from unsold property. So we've been assuming that, you need witnesses on a promissory note to make the promissory note valid. In this case, the unscrupulous person just found a paper with my signature on it. How could he turn that into a promissory note? And what we see is a witnessed and properly, a signed and properly witnessed promissory note creates, a liability that has more power than one that is not witnessed. When it's witnessed, you can even pursue that matter. Like if the guy is bankrupt and somebody else has seized his assets, you could actually go to that creditor and say, well, this guy owes me money. Maybe, I was in line first, and you're going to have to actually give me the money that you took from him because you took something from him that he actually owed to me. But if it's not witnessed, you can only present it against the unsold property, the property in the possession of the alleged borrower. One can collect repayment of a loan that is documented on a promissory note signed by two witnesses, even from the borrower's land that was sold, that's already gone out. With the document signed by the debtor, but not witnessed, the creditor may collect payment only from unsold property. Due to the potential for deceit with a signature on parchment, one provides a signature sample written on earthenware. Rav Yehuda said that Shmuel said, the law is in accordance with the statement of the rabbis in our Mishna, that each of the two signatories need testify only about his own signature to ratify the document. So if you only need a person to testify about his own signature and you don't need two witnesses to say that's a valid signature, that would indicate that the purpose of bringing those witnesses to court is not to ratify the signatures in the document, but rather to say, yeah, I signed it, I was there, I witnessed the making of the loan was a real loan, it was a valid loan, right? So it's not that they're coming to, be witnesses testifying about signatures, they're coming to be the witnesses of the original transaction. Right, Rav Yehuda said that Shmuel said the law is in accordance with the statement of the rabbis, that the witnesses you only need one witness to testify that is his own signature. And the Gemara asks, well, this is obvious, as the principle is, in a dispute between an individual sage and multiple sages, the law is ruled in accordance with the opinion of multiple sages. Since our Mishna said, Rebbe said that you need two witnesses for each signature, but the rabbis, the majority, said each person can testify about his own signature, even if no one else joins in testifying that is his proper signature. Since the majority held that way, why are we even questioning whether Rebbe's opinion? What is Rebbe's opinion? I mean, it doesn't matter, right? The majority said the witnesses can testify about their own signature, and that's enough. So why are we disputing this? So the Gemara explains, lest you say that just as there is a principle that the law is ruled in accordance with the opinion of Rabbi Yehuda Hanasi in disputes with his colleague, right? When there's a dispute between Rebbe and one other sage, the law always follows Rebbe. So maybe there's also a principle that the law is ruled in accordance with his opinion even when he disagrees with multiple colleagues. Maybe the majority disagreed with Rebbe, but Rebbe is the redactor of the Mishnah, so maybe Rebbe's always right. Therefore, Rav Yehuda teaches us that Shmuel said that the principle applies only to disputes with an individual colleague. Okay, so having established that, we can go back to the idea that, well, the majority said the witnesses can come to establish their own signature. They don't need a co-witness for that. Now, the Gemara provides a mnemonic for the names and patronyms of the Amoraim, the rabbis of the Gemara, associated with the statement that follows. So here, this is because this was an oral tradition, and try to keep all this straight, they had mnemonics. It doesn't help us that much since we're not so familiar with, we're not so comfortable with Hebrew. That's why we're learning in English, but nonetheless, Nun Chet for Rav Chinana bar Chiya, Nun Dalet for Rav Huna bar Yehuda, Chet Dalet for Rav Chiya bar Yehuda. Now, Rav Chinana bar Chiya said to Rav Yehuda, and some say it was Rav Huna bar Chiya said to Rav Yehuda, and some say it was Rav Huna bar Yehuda who said it to Rav Yehuda, and some say Rav Chiya bar Yehuda was the one who said it to Rav Yehuda. But anyway, what is it that he said? And did Shmuel say that the law is in accordance with the statement of the rabbis? But wasn't there a document that emerged from the court of Master Shmuel? And it was written with regard to that document from the fact that Rav Anan Bar Chia came before the court and testified about his signature and about the signature of the one who signed the document with him. So one of the witnesses testified, this is my signature, and that is the signature of the other witness, who presumably is not available to come here right now. And from the fact, and from the fact that Rav Anan Bar Chia came before the court and testified about his signature and about the signature of the one who signed the document with him. And who was that other signatory? It was Rav Hanan Bar Rabba. And from the fact that Rav Hanan Bar Rabba came before the court and testified about his signature and about the signature of the one who signed the document with him. And who was that other signatory? Rav Anan Bar Chia. Okay, so here there were two witnesses. Both came and each said, that's my signature, and that is the signature of my co-witness. And the other one said, that is my signature, and that is the signature of my co-witness. So that would be like what Rebbe said in our Mishna, that each of them needs to testify about his own signature and the other signature. Therefore, vis-a-vis each signature, two witnesses have come to say that is a valid signature. So Rav Yehuda said to him, that, in that case, right, meaning that that's a proof that when witnesses come to court to establish that a document is valid, you need two witnesses for each signature to say it's a valid signature. Whereas the rabbis said, no, each witness can testify about his own signature and doesn't need a second witness to testify that that is his signature. So maybe Rebbe is right and the rabbis were wrong. But Rav Yehuda said, that was a document for the benefit of orphans, right? So this was a document held to a higher standard. That was a document for the benefit of orphans. And Shmuel was concerned about the potential for an error of the court. And Shmuel thought, perhaps there is a court that holds that in general the law is ruled in accordance with the opinion of Rebbe, in disputes with his colleague, but not in disputes with multiple colleagues. And in this case, the law is ruled in accordance with his opinion, even in disputes with his multiple colleagues. And the court will not ratify the document if each witness testifies only about his own signature. Therefore, he thought, I will perform the ratification of the document in an expansive, in an exhaustive manner, in accordance with all opinions, to ensure that the orphans will not lose money to which they are entitled. So even though it's not necessary to have two witnesses testify about each signature, they went the extra distance since they were protecting the assets of orphans. Rav Yehuda, meaning, right, an orphan, meaning that he doesn't have, a child doesn't have a father who's going to come to court and make sure that everything is done properly. They're acting as the ward of the court, treating the orphans as wards of the court, and the one responsible for protecting their assets is going to go that extra distance. Rav Yehuda said that Shmuel said, if a document came before a court and the court ratified it, and then the document was produced in order to collect the debt, at which time the borrower contested its validity and claimed that it was forged, one witness who was a signatory in the document and a judge who ratified the document joined together to testify that the document is valid. Now you're getting that feeling that even in the old times, there were, certain individuals in society who are really litigious, sons of a gun. Some people will just say, okay, I owe you money. Here's the document. I pay. No need to ever go to court. Other people, hey, I don't think I owe you anything. Taken to court. The court says, that's a valid document. Pay. Right? Or maybe it was the guy wasn't in court, the one who's supposed to pay. The one who wants to collect the debt took the document by itself to court, and the court said, valid document. And so the court now issued a ruling, that's a valid document, and here's the ruling of the court. And the lender takes those two things, and he goes to the borrower, or let's say the heir of the borrower, and says, look, here's a valid document. I have proof that it's valid. Here's a ruling of the court saying that it's valid. Now pay me. And this person still won't pay. He says, well, maybe the document's forged, and the ruling of the court is forged too. So they have to go to yet another court. And how are they going to prove that the ruling of the court is valid? Now you bring the judge from the first court and say, I am the judge. That is my ruling. It's valid. Rami bar Chama said, how excellent is this law? Rava said, in what way is this excellence manifested? That which the witness testifies, i.e. authenticating his signature and confirming the incident that he witnessed, and the judge does not testify about that. The judge is only there to testify, I signed on this ruling is valid. So if you bring one witness from the original document and the judge to say that the ruling was valid, neither about the ruling from the court do you have two witnesses, nor about the original document do you have two witnesses, right? Combining the judge who ratified the document in a court and an original witness, those aren't actually two witnesses to the same thing. You can't say those are two witnesses to the same matter. So rather, when Rami bar Yecheskel came, he said to him, do not listen to those principles that my brother Rav Yehuda bar Yecheskel established in the name of Shmuel with regard to a witness and a judge joining together to testify. They can't do that. Now we're on 21b. Then the Gemara relates that Ravnai, the brother of Rabbi Chiya bar Abba, happened to come and sell sesame. And he said that this is what Shmuel said, a witness and a judge joined together to testify. And a Maimar said, how excellent is this halacha, this law? And Rav Ashi said to a Maimar, due to the fact that Rami bar Chama, the father of your mother, praised it, you also praise it? Rav already refuted that statement and proved it incorrect. Don't just say it's correct because somebody else said it's correct. We have a bigger, higher source that said, no, a witness to the original document and a judge from the court that ratified it cannot join together to say that is a valid loan. Rav Safra said that Rabbi Abba said that Rabbi Yitzchak bar Shmuel bar Marta said that Rav Huna said, and some say that Rav Huna said that Rav said, with regard to three judges who convened to ratify a document, and two of them recognized the signatures of the witnesses on the document, and one does not recognize them. As long as the two judges did not yet sign to ratify the document, they testify and authenticate the signatures before the third judge. And based on that testimony, the third judge signs the document of ratification together with the first two judges, right? So you have a court of three judges. Somebody brings a document to be ratified. Well, two of the judges happen to know the witnesses and can say those are valid signatures. So those two judges are going to act as witnesses, not as judges. And then the remaining judge will be the one who acts on behalf of the court and ratifies the document. However, once the two judges sign the ratification, they may not testify before him and have him sign the ratification. The formula of the ratification is we verified and ratified this document in a forum of three. Since when the first two judges signed the ratification, they were not a forum of three, because two of the judges were witnesses, so there were not three judges there. The ratification is invalid. So the Gemara asks, and do we write the ratification of a document before all of the judges verified the signatures of the witnesses? But didn't Rav Papi say in the name of Rava, this ratification of judges that was written before the witnesses' related testimony about their signatures is invalid, even if the witnesses later authenticate their signatures, as it seems like a lie, since when they drafted the ratification, they were not yet aware that they would be able to ratify the document. Here too, when the judges drafted the ratification, before the third judge can verify the signatures, it seems like a lie. And the Gemara answers, you're right, so rather amend the statement and say, as long as the two judges did not yet write the ratification of the document, they testify and authenticate the signatures before the third judge, and based on that testimony, the third judge signs the ratification together with the first two judges. Right? So two judges can act as witnesses and say, those are valid signatures. The judge hears their testimony. Okay, we've established that these signatures are verified. Now the two witnesses who are actually judges come around to the other side of the table, and the three judges together say, we establish that these are valid signatures, and as a court, we ratify this document. It is a court-ratified document. Now the Gemara notes, conclude from the statement of Rav Huna, three laws. Conclude from it that a witness can become a judge, as the two judges who testified to authenticate the signatures signed the ratification afterwards in their role as judges, and they were not disqualified due to a conflict of interest. And secondly, conclude from it that judges who recognize the signatures of the witnesses do not require other witnesses to testify before them. If they recognize the signatures, their testimony counts in court, even though they're going to act as judges also. And conclude from it, third law, that in cases involving judges who do not recognize the signatures of the witnesses, then additional witnesses are required to testify before each and every one of them. And no judge may issue a ruling based on testimony brought before the other judges. The judges who are going to sign the ratification of the document all have to witness the testimony. They can be part of that testimony if they themselves recognize the signatures, but otherwise all three judges have to hear testimony from two witnesses that the document is valid. Now, Rav Ashi strongly objects to the conclusions drawn by the Gemara. Granted, the fact that a witness can become a judge, we can conclude from the statement of Rav Huna. However, the fact that judges who recognize the signatures of witnesses do not require other witnesses to testify before them cannot be concluded from the statement of Rav Huna. Perhaps I will say to you that actually judges require witnesses to testify before them. And here, in this case, it is different, as the requirement of the statement of testimony is fulfilled with the testimony of the two judges before the one judge who did not recognize the signatures. However, in a case where there is no statement of testimony at all, there could be no ratification of the document. And furthermore, with regard to the conclusion that in cases of judges who do not recognize the signatures of the witnesses, witnesses are required to testify before each and every one of them, perhaps I will say to you that actually, in general, witnesses are not required to testify before each and every judge. And here in this case, it is different, as were it not for the testimony of the two judges before the third judge, the requirement of the statement of testimony would not be fulfilled at all. So in a case where there is other testimony, perhaps one may rely on the knowledge of others in order to ratify the document, right? Maybe not every judge has to hear the testimony. Maybe one judge can rely on his fellow judge who says, I heard the testimony, it's good enough for all of us. So the Gemara relates, Rabbi Abba sat and he stated this law that a witness can become a judge. And Rav Safra raised an objection to the opinion of Rabbi Abba from a Mishna in Tractate Rosh Hashanah, which we covered, where we talked about the Sanhedrin in Jerusalem hearing testimony that witnesses had seen the new moon, right? When they established that a new Hebrew month had begun, when they didn't have a preset calendar, and they would declare the new month has begun from the testimony of two witnesses. So if three people saw the new moon, and they constitute a court, right? What if the judges themselves are the ones who witnessed the new moon? If three people saw the new moon and they constitute a court, two of them should stand and seat two of their colleagues to sit near the remaining individual judge. If they're going to be the witnesses, they're no longer the judges. They should bring in two other Torah scholars to act as the second and third judge, and the two judges who are now witnesses only do the job of witnesses. And the two should testify before the three judges, and they should then recite the standard formula for sanctifying the month. The judges say, sanctified is the month, sanctified. Two others must join the original judge to form a tribunal of three judges, as an individual judge is not deemed credible to sanctify the month by himself. And if it enters your mind to say that a witness can become a judge, why do I need all this? In the case of the Sanhedrin, sanctifying the new month, since two of the judges witnessed the new moon, and if witnesses can also act as judges, why do they need to bring in two additional judges to hear the testimony of the witnesses? Let them act as witnesses first and then as judges to sanctify the month. It's the fact that they don't do that indicates that we don't allow witnesses judges to act as both witness and judge. So Rabbi Abba said to Rav Safra, that Mishnah was difficult for me to understand as well. And I asked Rav Yitzchak bar Shmuel bar Marta about it. I'm almost done, by the way. If you have any questions or comments, get them in. Right? So Rabbi Abba said to Rav Safra, yes, I had trouble with that too. That in the case of sanctifying the new month, we don't allow two men to act as both witnesses and judges. And so I asked Rav Yitzchak bar Shmuel bar Marta about it, and Rav Yitzchak asked Rav Huna, and Rav Huna asked Chia bar Rav, and Chia bar Rav asked Rav. And Rav said to them, leave the case of testimony to sanctify the month, as it is mandated by Torah law, and its guidelines are more stringent, and that's why those two judges can't also act as witnesses. But when we're talking about the requirement of ratifying documents, this is mandated by rabbinic law, and therefore the standards are less stringent, and it is permissible for two of the judges to act as witnesses and say, we're familiar with those signatures. Those are the valid signatures of the witnesses of the original document, and then they can continue in their role as judges to ratify the document. That's what I've got for us today. Let's see if we have questions or comments. On Kesubos 21. Nina's telling me that were many prayers for my healing. Thank you so much. I appreciate it. At the top of the show, I mentioned that I tested positive for COVID last night. I feel fine. My sense of taste and smell were quite diminished. But thank you so much for praying for my health. That it should be a light case. I should get that, get my taste and smell restored soon. Amen. Thank you so much, everybody who prayed for me. And I pray for anyone in our audience who is ill that you should have a refuah shlema. Christo, kind of why I often reduce the font size if I'm going to print some things out. I recently learned of a new invention that's designed to remove ink from paper to reduce waste for both. I guess commenting on the fact that earlier I said that in the digital age, rather than use less paper, we started to use much more. Since, word processing and just printers and just, you made a mistake on page 10 of the contract, print the whole contract again. That's what people do. Sharon, it's odd. I was just thinking today after reading this. We have known for a long time that there are errors in our names on our ketubah. Sharon must be talking about her own ketubah with her husband. Our witnesses are dead. If I wanted to get a new ketubah with our names corrected, what would we have to do? I don't know if the rabbi is still around or not. So clearly a question for your local rabbi. I don't know the answer. I'm so not an expert in this field of law, but it appears to me that what you would be creating is not a document, recreating the ketubah that you signed on your wedding day. But rather, you're just creating the ketubah now. And you could probably even put language in it that says this supersedes any previous ketubah. Create the same obligations, rights and obligations, that you had in the original contract. And now, what the witnesses would be signing is not whatever the original document was, but this document. And you're a lawyer too, right, Sharon? I mean, it would just be like a new contract that supersedes the old contract. Because the witnesses from the original one aren't there. So I would think that what you're creating is just a new document to replace the old one. Now, you would also say we're married, right? And so what maybe you're asking me is, okay, but who's going to testify the fact that we were married in a proper marriage? And maybe you have to find people who were there, right? And say, I witnessed Sharon and her husband getting married. And it was a valid wedding, and so the rights and obligations created by this marriage contract are indeed related to a valid marriage. But now I'm just, speculating. You got to ask your rabbi. And finally, Bill, one of the things I like to remind folks about our 100-odd page documents nowadays is an axiom I heard from the Scottish facilities manager of my old seminary dormitory. Everything on the page, I can't do a Scottish accent, won't try. Everything on the page is something someone has tried at some point. Right, or what I like to say about contracts is that everything on that page is a dispute that arose at some point in the past, right? Like especially when you look at disclaimers that on websites that are selling products, right? And then it's like that long verbiage or, anytime you sign, what do they call it? Like you get a new app on your phone, and you agree to the terms, right? The statement of terms of the app developer and of the app store from Apple or Google. And it's like, it's so much language that nobody reads it. But why is all that language there? Because at some earlier time, some company got sued by some law firm, maybe in a class action suit, and the verbiage just multiplies over time. And in the same way that the Talmud has grown to so many volumes, so do contracts grow to include all those disclaimers. At any rate, that's what I've got for us today. All right, it's Wednesday, so with God's help, we'll be together again tomorrow night, 6 p.m. Pacific, the regular time for